The next matter to come before the court is State of Ohio versus Natalie Tucholsky. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping track of time. You can always also reference the time clock on the wall. The arguments are being recorded, so please keep your voices up and remain at the podium, and do not use the names of victims or minors, as we, like I said, are recording these arguments today. The court has read your briefs. We're ready to proceed when you are. Would you like to reserve any time, Attorney Sheldon?
Yes, Your Honor, reserve 3 minutes. Good morning, Your Honors. Good morning, Ms. Philbin. My name is David Sheldon. I represent the appellant, Ms. Natalie Tucholsky, in this matter, pending before the Court of Appeals, Judge Hensel, Judge Carr, Judge Stevenson. Your Honors, I'd like to focus, I know there's 4 assignments of error in this brief. I'm not going to be able to cover 4 assignments of error. I'm going to focus my arguments on assignments of error number 1 and number 3. The first one dealing with the trial court judge's exclusion of Dr. Harry Plotnick, an expert retained by counsel on behalf of Ms. Tucholsky, as well as assignment error number 3 dealing with the reasonable articulable suspicion to have Ms. Tucholsky perform standardized field sobriety tests and continue her detention. With respect to assignment error number 1, the focus of that assignment of error, as you know from the briefs, is the trial judge in this case excluded Dr. Plotnick from testifying after he had driven up previously from Cincinnati to the originally scheduled suppression hearing, which the judge continued because there was discussion about me, counsel, not providing an expert report. Before the hearing, I explained to the court, under the rules of criminal procedure, defense is not obligated to provide an expert report prior to a suppression hearing. I mean, it's really the pre-trial stage of proceedings. The state, just so we're clear, the state in this case had the burden of establishing that the testing was done in substantial compliance with the OAC standards in effect at the time, as well as the statute. So the state of Ohio, or the defense, had no burden in this case. So the fact that the judge ordered us to supply expert reports in advance of the suppression hearing is a change in the rules. I mean, if the House Supreme Court felt that we should have a rule saying, hey, parties should submit expert reports in advance of the suppression hearing, we would clearly have such a rule. We don't have that rule. Nevertheless, the court ordered us to supply expert reports 10 days in advance of the reset suppression hearing. Now, on March 5th, the suppression hearing was set for March 19th. On March 5th, I, on behalf of my client, made a motion to continue that hearing because my expert, due to his schedule, was unavailable for the hearing on March 19th. The acting judge at that time granted my motion to continue the suppression hearing to May 7th. The state of Ohio, by motion in limine on March 9th, found the motion to exclude my expert, even though I had the right, my client had the right to rely upon that continuance. And the court granted me the leave to supplement my brief with State versus Bellamy, which I think is directly on point. It's a House Supreme Court case that deals with failing to supply an expert report 21 days in advance of trial. We don't have a trial here. We have a suppression hearing. Totally different, but nonetheless, in that case, the state failed to timely supply an expert report in advance of the trial. In fact, 6 days before the trial. The defense doesn't object until they're in the middle of the trial and says, hey, at lunch recess, we object, Your Honors, or Your Honor, to this expert testifying. We didn't get a timely expert report. The judge in that case, common pleas judge, says, no, I'm letting the state's expert testify. He testifies. The defendant, in that case, gets convicted of all counts, sexual offenses. Goes up to the 5th District. 5th District says, no, that was not harmless error. That was prejudicial error. You did not supply a timely expert report citing another House Supreme Court case. It's reversible error. We're reversing this matter to the trial court. However, Mr. Expert for the state, you don't get to testify. You're barred from testifying at the retrial. Now, the state takes that up, goes to the House Supreme Court. House Supreme Court says, no, that is wrong. Where that report's been supplied and it's set for a retrial, that state's expert's not barred from testifying. It's analogous to this situation where the matter is continued to May 7th. My expert report supplied March 16th, which is 3 days before the originally rescheduled suppression hearing. So the state's already got its expert report. We're now set for May 7th, and the court excludes that expert. And it's significant in this case because Dr. Plotnick was going to testify as to his opinions on the NIST traceability in this case. And another thing the court should be aware of, in the middle of the hearing, the suppression hearing went forth on May 7th, the materials that were supplied to the defense were not the correct materials. In the middle of that hearing, they switched gears and supplied different certificates of analysis. So my expert, even before we got to this hearing, did not even have the correct materials, and it was by letter dated February 25th that their expert, Jenna Wallach, supplied to the state of Ohio, which I received a copy, saying here are the records that we intend upon relying upon, which were the incorrect records, and then it was subsequently provided during the middle of the suppression hearing. So, Your Honors, in terms of the assignment error number 2, where I argued, well, let's get to the argument itself on the NIST traceability. You have to take into account I didn't even have, my expert didn't even have the correct records even to rely or issue opinions upon at that point in time. So I'm asking the court to grant the reversal of the trial court's overruling the motion to suppress on assignment error number 1 because it prejudiced, and the trial judge acted arbitrarily. He changed the playbook in this case, and he really created a new rule saying, hey, I don't care what 16K says about trial, I'm creating a new rule, you got to supply an expert report 10 days in advance of your suppression hearing. And again, it's not my burden, it's not the defense burden to prove or show by substantial compliance that the state complied with the Ohio Administrative Code in establishing that the dry gas standard in this case was traceable to NIST. And I rely upon State versus Bellamy as well as 16K and the facts in this case. With respect to assignment error number 3, in terms of the reasonable articulable suspicion, it's interesting when you look at the facts that I cited in my brief, as well as the court's recitation of facts, he goes and points to all the facts that would support not finding reasonable articulable suspicion, in this case, to have Ms. Tucholsky move from the car and have her go through a series of field sobriety tests. There was not a late hour, she was not coming from a drinking establishment, no odor of alcoholic beverages, no bloodshot eyes, no slurred speech. She had an admission to consuming alcohol, but classic indicia of impairment were not present in this case. The trial court puts a lot of emphasis on, well, we had that reliable report from her husband back at the scene of this alleged criminal damaging. Hey, he said that she's not like this unless she's drinking a lot. Well, the court said a reliable source, and I take issue with that. They're going through a divorce. The police officer had just been there investigating a criminal damaging complaint, allegedly where she threw a brick through a window and bent his license plate on his truck. I don't think he is a detached, neutral source when he's going through a divorce and he wants her arrested for allegedly committing criminal damaging. So
he, whether or not he's reliable in terms of what makes her behave in this manner, didn't the officer investigate the what happened at the home prior to having her do field sobriety tests? Didn't he have some independent
well, Your Honor,
understanding of what had happened there?
He did, Your Honor. He talked to, well, his independent investigation was talking to Mr. Tucholsky. Again, that's a credibility issue. Is he telling the truth about what she did? He's claiming to be an eyewitness. I saw her throw a brick through the window. I saw her bend my license plate. Well, that's a matter for another day in a jury, perhaps, or a judge trial. But he's making the report. He's not a disinterested party at that point in time. So the officer is getting hearsay information, which I know is admissible at a motion to suppress hearing, but in terms of the reliability of that information, I say it's highly suspect, even though the court may rely upon hearsay and is the determiner of facts. I don't think pointing out to factor number 4 under the Evans analysis, or whatever factor that is in terms of receiving a reliable report of intoxication. It's not like you're a detached motorist driving down the highway, seeing a car weaving all over the road and calling 1-800-GRAB-DUI. We don't have that here. We don't have that. Motorist has no axe in the game or iron in the game here. We have somebody that does have a bias or interest in the outcome. So the court relying upon that factor is not, I would suggest to this court, is not a reliable factor in this terms of this case. And I think the other indicia of impairment that the trial court pointed out was, well, she pulled out her debit card, not her driver's license, and dropped it to the ground. Okay, I suggest that that's probably a common occurrence, whether someone's on the influence of alcohol or has not consumed alcohol. They're nervous when they get pulled over. I think from the record she was highly agitated, she was speaking fast. And then the other thing the court, I think, pointed out was, well, she quote-unquote had a bunch of drugs with admitting to consuming alcohol and changing that number of drinks. I suggest to the court that she indicated she was taking prescription medication. The officer in this case, Ghetto, is not an expert on drugs or impairment, so drug impairment. So I don't think that is also a reliable factor, and I distinguish State versus AC from this particular case. And in AC, if you recall, the driver was under suspension, should not have been driving. My client was not under suspension. There was no indicia of erratic driving when he was following her. She wasn't swerving, she was following the speed limit. So there's all these factors the court pointed out as demonstrating grounds not to have her exit the car and administer field sobriety tests in this particular case. Nonetheless, the court found that there was, under the totality of circumstances, reasonable articulable suspicion to detain her to administer field sobriety tests.
And counsel, you're right now at that 3 minutes.
Okay. So I know the judges, I know you read these briefs and are very well aware of the facts and the record. I ask you to consider the other sentences here that I've not obviously argued here in court today. And thank you. I ask that the respectful request of the 9th District Court of Appeals reverse the decision of the trial court on assignment to error number 1, particularly number 3, as well as those other ones I mentioned. Thank you.
Thank you, counsel.
Good morning. May it please the court, my name is Megan Philbin. I represent the appellee of the state of Ohio in this appeal. This appeal arose after Ms. Tucholsky had entered a no contest plea to OBI and also in the criminal case as well. Those were companion cases. But so appellant raises 3 assignments of error. I'm going to go through in order. And so the first assignment of error was that the trial court had erred when it granted that motion in limine that was filed by the state in the standard review as abuse of discretion. So I want to just give a little bit of background leading up to the motion to suppress. So the issue that was raised, one of the issues that was raised for the motion to suppress was the traceability to NIST. So it's a very scientific issue that needs to be examined. So the state of Ohio had asked Jenna Wallach from the Ohio Department of Health to testify in that hearing. Jenna Wallach is, in the state's position was originally, she was more of a fact witness for the state, not necessarily an expert on our side of things, because she does maintain the records for the Ohio Department of Health. She also does make sure that the Intoxizer 8000 is maintained in accordance with the Ohio Administrative Code. So she's the individual who oversees the individuals who do actually calibrate these devices, and she maintains the records and ensures that the dry gas standard, she's actually the person who does purchase the dry gas standard, and she has firsthand knowledge of whether or not that item is traceable to NIST in the sense that the documentation she gets from the manufacturer of the dry gas standard. So originally that was the state's position, but we were using her for that testimony. On the eve of trial, not 24 hours beforehand, Ms. Tucholsky provides to us this information that they're going to use an expert. The state was prepared.
Counsel, when you say trial, you mean the hearing?
Yes, I apologize. The suppression hearing. So on the eve of the suppression hearing, it was indicated to us that Ms. Tucholsky would be using an expert. We had never received any kind of expert report. We did not know what this individual was going to say or point out what the problem was. And the state had filed this motion to strike that witness because we wanted to be prepared. It's our burden at the motion to suppress. We wanted to be able to have, if we needed another witness to come to the trial, to have somebody lined up to be able to rebut whatever that issue may be. So the court had, we all appeared that day for the motion to suppress. The court had denied that motion from the state, and pursuant to Criminal Rule 16L, the trial court had told us, the parties, the state and defense counsel, to submit expert reports in this case. So they required the parties to submit expert reports 10 days prior to the next scheduled hearing. And the trial court had issued this judgment entry explicitly stating what was required of the parties. So the state, on our side of things, we ended up preparing an expert report. We had Jenna Wallach, she prepared it, and she provided her curriculum vitae as well. And that next scheduled hearing date was March 19th, and 10 days prior was March 9th. And the state, as soon as we had our information, we had supplied it to Ms. Tucholsky. It was not supplied to us 10 days prior. The court was explicit in the judgment entry indicating that no other continuances of this hearing would be had because of what had happened at the prior motion to suppress hearing. It was, the court wanted to just have everybody, come to the hearing prepared, ready to go with all the information. There was a motion to continue. The state doesn't deny there was a motion to continue by defense counsel, Ms. Tucholsky, and it was granted by the court. State's position and...
Counsel?
Yes.
Considering what you just said, that you thought they had to have it presented to you March 9th, because the March 19th hearing, that would have been 10 days before, because that's what the order required.
Yes.
But the order also said no further continuances. So you were operating under the impression that there was ordered to be no more continuance, so that was a drop dead date. But in fact, it was a continuance, so how could that be a drop dead date again?
Well, I will say this. So Mr. Sheldon indicated that the motion to continue was granted by an acting judge. Our understanding, at least in this municipal court, is when this particular court indicates that there will be no further continuances, there are not further continuances. So the state's understanding, given our experience in this court, is that that was a hard deadline. And it was an exception because there was an acting judge who happened to grant that continuance.
Did the state oppose the motion to continue the March 19th date?
I believe that we did file a motion objecting to the continuance, but I believe that, from what I recall, the motion to continue was granted prior to the consideration of it. Generally, they get granted pretty quickly when there's an acting judge in place at the Medina Municipal Court. So the state, in response to this, we had filed this motion in limine, which was granted by the court, and the trial court's basis was Criminal Rule 16L, which is different than Criminal 16K, which applies to the disclosure of expert reports in trials, which I think is significant because I know Mr. Sheldon had filed a supplemental brief with that new case out of the Ohio Supreme Court, and that addressed, one, a trial, but also Criminal Rule 16K, so disclosure for that. What the trial court in this case had done was created a court order for scheduling so that all parties could have this information at a specific certain date. It wasn't 21 days prior to a trial. They had created this order for the parties to follow. And so the state's position that the new case that came out of the Ohio Supreme Court is not necessarily on point to the specific issue that we're dealing with here in this case. So the state's position is that it's Criminal Rule 16L, which would dictate whether or not the trial court in this case could permissively create this like briefing schedule type of order that they had done. So,
And counsel, so we're all on the same page here, because I heard that you indicated you filed a separate, I'm sorry, that the defendant filed a supplemental brief. So the brief was stricken, but the supplemental authority was permitted, allowing argument today, but I just wanted to make sure that you were clear, because it all just happened.
okay, I appreciate it. Thank you, Your Honor. The appellee would ask that the first assignment error be denied on that basis. I'm going to go into the next issue, which is the Ms. Tucholsky had raised that it was the trial court's error to deny the motion to suppress dealing with this.
Counsel, before you proceed to the next assignment,
Yes.
I just wanted to ask, how was the state prejudiced in this respect, in regard to the motion to suppress, since the suppression hearing was continued and you had the documents, the expert's report long before the hearing time?
To be quite honest, I don't necessarily believe the state is prejudiced in this case. We did have the documents. I do not recall the specific date. I believe Mr. Sheldon indicated it was 3 days prior to the March 19th date. So we did get the documents at some point prior to the hearing. It just was not to the schedule that the court had issued. So I do want to mention also that in this, in Mr. Sheldon's argument that when we're getting into the records that were provided for the traceability to NIST issue, Mr. Sheldon indicated that the wrong records were provided to him. The state of Ohio had submitted all of the records to Mr. Sheldon originally and had provided the correct records originally. State's witness Jenna Wallach had created a smaller exhibit that only had a few documents pulled from it that she intended to use at the motion to suppress. That was what Mr. Sheldon is pointing to is where he received the wrong documentation. That was in the shortened packet that Jenna Wallach had created for the motion to suppress. But Mr. Sheldon did have all of the original documents in the original disclosure from the state of Ohio, just in a separate exhibit. So it was provided to Mr. Sheldon. And I know that there's discussion that his expert witness did not have the correct information when he was making his opinion. And that's correct in the sense that shortened exhibit didn't, but Mr. Sheldon did have the other exhibits that had all of the documentation, the correct documentation. So I just wanted to clarify that.
So everything in the shortened exhibit was included within the original disclosure of information?
I think the issue was there was one document that was incorrect in that shortened exhibit. But everything else in that exhibit was correct, and it was in the original packet that was provided to him. During the actual suppression hearing, it unfolded that Ms. Wallach noticed this is the wrong document and was able to put in from the original packet the correct document, so it was transferred over. So during the hearing, it was corrected, and everybody was aware of the correction of that shortened exhibit.
Thank you.
The shortened exhibit was created just for ease of not having to go through all of the COBRA documents. So as it relates to the error of the trial court to deny the motion to suppress with the NIST issue. So this is a mixed question of law and fact, and this state's position that as it relates to the facts in the record, there's competent, credible evidence in the record to establish the traceability to NIST. Excuse me. So the state had Jenna Wallach testify, and she is the program administrator for forensic toxologist for the Ohio Department of Health. And like I indicated before, she does oversee the annual certifications of the Intoxilizer 8000. Trains and supervises the breath test inspectors for the Ohio Department of Health and purchases the dry gas standard was used in this particular case. And so it's her job to ensure the accuracy of the dry gas standard and to make sure that she is complying with the Ohio Administrative Code. She had explained that there are two ways to establish the target concentration in the dry gas control. Excuse me. That the equipment, there's two ways to establish traceability to NIST, and one would be the equipment used to mix that original dry gas standard is calibrated with the NIST traceable weights. And then the second way is once it is mixed, it is compared to a certified reference material. And so that's where we get the traceability in this case is that we have traceability from the actual breath test itself all the way to the certified reference material. And there must be an unbroken chain, between these two documents to show that in this particular case, there is traceability to NIST. There's substantial evidence in the record that Ms. Wallach was able to testify to and prove in the documentation that these two documents do trace to each other, and they trace to NIST. Excuse me. So based upon the documentary proof and General Wallach's testimony, the state's position that there is established traceability to NIST, and I'd ask that assignment of error be denied. Excuse me. Sorry. Also, I think it's important to note that Ms. Tucholsky was able to submit into the record for the motion to suppress her exhibits, and the court relied heavily upon her exhibit in coming to its decision in denying the motion to suppress. One of the issues that was to be raised, that Ms. Tucholsky indicated her expert would raise, is that capability of traceability to NIST is not equal to traceability to NIST. And the documentation that Ms. Tucholsky had provided in her exhibit, which is in the record for the motion to suppress.
Counsel, do you need to take a drink?
If you don't mind, just for a moment, I apologize. Excuse me.
It's an entire day of not ordinary things happening.
Thank you. You were asking a question, I believe?
No, the question was, do you need to take a break? I could
Okay.
tell you were struggling, but thank you.
All right, thank you, I apologize. And then getting into the third assignment of error here was an error of the trial court to deny the motion to suppress specific to the continued detention, substantial compliance, and the scenario field sobriety test and the probable cause issue. So in this case, we're not just dealing with someone who is stopped on the roadway. It's a traffic offense first, and then we go into an investigation. It actually starts as a criminal complaint by Ms. Tucholsky's husband, and I designate him as ST in this case. So ST calls the police and indicates that there's this criminal damaging, and the police come out and investigate that first. So they see, he makes the allegation, they also see the damages themselves, they make this report, they leave. And that victim then calls back and says, the defendant is back, so Ms. Tucholsky is back, and she then threw beer cans on the front lawn of this property. Officer comes back, and he actually does see that there is now beer cans in the front of the property that were not there originally. And also it sees Ms. Tucholsky operating her vehicle. She ends up pulling back into the address, that Weymouth Road address where the incident had occurred, and she gets out of the vehicle. She does not have shoes on. She's talking extremely fast. She's, excuse me, has glassy eyes, and when the officer starts speaking with her to investigate the criminal complaint, he's also getting these indications that Ms. Tucholsky was also under the influence of alcohol. She hands him the dipper cup, but she also drops it on the ground, doesn't really realize that she's dropped it until he mentions it, then she picks it up. Then he asks her about consumption, and she says she's had alcohol, she had 1 beer, and then changes that to 2 beers. So all of these factors, the initial criminal complaint, and also the victim's statement that Ms. Tucholsky only acts this way when she's consumed alcohol, she's impaired by alcohol, all of these factors lead to an officer having enough for continued detention to at least do standardized field sobriety tests with Ms. Tucholsky and determine whether or not she was impaired by alcohol and should not be driving. So the state would respectfully request, I know I'm not getting to everything, but that the assignment of errors should be denied. Thank you.
Thank you, counsel. You have just over 2.5 minutes.
I'm sure the court will hold me to that.
Oh, yeah.
Thank you, Your Honors. Just briefly, with respect to the issue of prejudice, I'm glad the court brought that up. You've heard from the state of Ohio through the prosecutor's office that they were not prejudiced by this situation. So I think that's significant. As I said, there's no requirement to supply expert reports. They have the burden of establishing. Let's assume there were no expert reports ordered, period. They come into a hearing, they can call an expert, Ms. Janet Wallach, who's supposedly their expert. I don't have a right to have her expert report before that hearing. If they call her, I have to be prepared to cross-examine that person within the bounds of the law and zealously representing my client. Hopefully I have enough information supplied through the discovery process to cross-examine that witness, and she's testified many times, so she does have a track record, and there are plenty of court hearings where you can access her prior testimony, but there's no requirement that she provide an expert report to me before she testifies, or any other expert that could be called by the state of Ohio in a suppression hearing. So,
Well, counsel, there's no requirement in the rules, but there is an order in this case, a court order requiring. Are you saying that's completely ultra vires, and the trial court can't order that?
now, the court obviously has power to issue an order, but in this particular situation, with my expert, number one, well, when she brings up the issue of the material supply, it was a letter dated, this is their expert report dated February 25th with the incorrect certificate of analysis. So this is what they're saying is going to be your testimony about. Obviously, there's other certificates of analysis, but this is what he's got to focus on. So before we even get to assignment error number 2, my expert does not even have the correct material in terms of what the state is focusing on to say that there's traceability in this case. So, and then when it's continued, and Ms. Philbin brings up, well, acting judges are quick to issue these. I had trial judges issue orders continuing cases before I've even gotten their motion to continue. So it's not just the acting judge, it's judges do this, whether it's the police officer's sick, he's at the academy, he can't be there, that happens routinely before I even know about it. So, but the fact is that,
Wrap up pretty quickly here.
thank you, the fact is that we were prejudiced, we did not have the ability to call our expert to testify and issue his opinions as to why this was not mistraceable. I know we made the arguments, I point to the court to page 11 of my statement of facts. It's the exact reason why this was not mistraceable based on all the prior certificates. Thank you.
Counsel. Court will take the matter under advisement to issue a decision which will be mailed to all parties to this appeal, as well as posted on the House Supreme Court website. Thank you both very much for your arguments today and for coming to the snowy Summit County.